Hello and welcome everybody. In today's video, we shall be discussing the most important judgments of the month of December. I am Sana Pervez, the legal expert for Hitbullseye. So let us get into the video and start discussing the four most important judgments that were given from the 1st of December to the 15th of December. In our first case that we shall be discussing today, National Commission for Women versus Union of India and another. Now, in this particular case, the Supreme Court issued a notice in a plea filed by the National Commission for Women for enforcement of fundamental rights of minor Muslim women seeking uniform application of penal laws to Muslim women while contracting marriage. Essentially, what happened in this particular case was the National Commission for Women had filed an appeal or had filed a case against the Union of India, that is the central government, stating or requesting the Supreme Court to ask the center to bring down the age of marriage or rather to bring up the age of marriage from 15 years to 18 years of age. Now, as you might know that under the Muslim personal laws, a Muslim woman is considered of marriageable age or the age of majority when she turns 15 years of age. Now, however, in all the other laws, like in the secular laws, it is considered that the age for legally getting married is 18 years for a woman, and it is 21 years for boys. That is, for men, it is 21 years in all the other secular laws. However, because we follow the system of personal laws in our country, so that is why different laws are applicable to different religions. And whereas the 18 and 20 years, 21 years is applicable to all the other religions, in Muslims, it remains 15 years of age. Now, in this particular case, the Supreme Court essentially held that it is agreed that at the age at 15 years of age, which is the presumed age of gaining puberty of a Muslim woman or of a woman amongst Muslims rather. So it is agreed that physical maturity is gained in a woman. She will become at 15. There is a probability that she will become biologically capable of bearing child and having sexual intercourse. But at the same time, it cannot be agreed that she will also be physically and mentally and psychologically adult or mature at the same time. In order to gain that kind of a maturity, so few more years are required, and the age should and the age of maturity should be at parity with all the other laws that are prevalent in our country. And becoming this, it will also be in consonance with Article 14 of the Constitution, that is the right to equality. A woman who is a Muslim woman should have the same rights as the woman of any other religion, essentially. And also, it is a step towards the Uniform Civil Code that is much talked about under Article 44 of the Constitution of India. So, proceeding forward, let us have a look at our next judgment, which is Kamla Neti daughter versus Special Land Acquisition Officer. This is the second most important judgment which is given under the category of family laws in this course of 15 days. So, this is essentially with the laws regarding the scheduled tribe women. The scheduled tribe women are not entitled. The Supreme Court stated that the scheduled court women are not entitled to any right of survivorship under the Hindu Succession Act. The Supreme Court in this case urged the center to bring suitable amendments wherever possible. Now, in this case, essentially what happened was, let us try to understand where the Hindu Succession Act is applicable in the first place. The Hindu Succession Act is applicable under Section 2. Under Section 2 of the Hindu Succession Act, it is basically discussed where all the Hindu Succession Act is going to be applicable. It is applicable to all the persons who follow the Hindu religion, the Sikh religion, the Buddhist religion, as well as the Jainism religion. it is not applicable on categorically on the people who are Muslims, Jews, Parsis, and Christians. Now, with respect to the scheduled tribe women, or with respect to the scheduled tribes rather, it shall only be applicable as per section 2, subclause 2 of the Act. Now, let us have a look at what the section essentially entails. The section states application of the Act, notwithstanding anything containing in subsection 1, nothing containing in this Act shall apply to the members of any scheduled tribe within the meaning of clause 25 of Article 366 of the Constitution unless the center government by notification in the official gazette otherwise directs. So essentially what we learn from this is that the Act, generally speaking, the Hindu Succession Act is not applicable to the people of scheduled tribes. However, the people who have been listed in the or who have been scheduled in the as a scheduled tribe, the center by a special notification can make this law applicable to them categorically. But unless there is no specific notification in this regard, the law is not going to be applicable on these people. So, with regards to the same, the Supreme Court stated where a scheduled tribe woman had approached the court stating that she also wanted to enjoy the right of survivorship, which is given under the Hindu Succession Act. The Supreme Court noted that, firstly, survivorship is, it means that if one owner dies, his shareholding will be passed down to the remaining owners. That essentially means that if there are two, three, four, any number of joint owners of a certain property and one of them dies, the remaining people remain or stay the owner of that thing. So essentially what used to happen before the amendments of 2005 amongst Hindus, as well as what happens amongst the scheduled tribes even now, some scheduled tribes, that is, that when the right of when a person or the father used to pass away, when the father used to die intestate, then the property used to go to all the survivors, and the survivors were only male survivors. So the property used to pass on or devolve by survivorship. However, it would only devolve on the men of that family and not the women of that family. However, there was an amendment of 2005 which was brought in order to reduce the gender discrimination that was seen prevalent in the Hindu Succession Act, in the Hindu succession laws as well. So, therefore, it did away with such kind of a discrimination, and it made the Hindu women also co-partners. Essentially, the Hindu women also had, after 2005, now the Hindu women also have an equal right in survivorship as the Hindu male. However, if we see that because of the center notification that we studied under section 2 clause 2 of the Hindu Succession Act, this benefit cannot be extended to the scheduled tribe women, and therefore the Supreme Court has asked the center to pass on such notifications in the official gazette. Under this provision, the Supreme Court has asked the center to quickly pass such notification so that the scheduled tribe women can also take the benefit of this section. Again, this is in consonance with Article 14 of the Constitution of India. Now, proceeding to our third case, this is Tarun Tejpal versus the state of Goa. In this particular case, it is still an ongoing case and the trials is still pending. It is essentially a rape case of in which the accused is Tarun Tejpal, who was the editor-in-chief and co-founder of the Telka magazine. In 2013, during a festival in Goa called Think, he was accused of an incident of rape on two particular dates in which he sexually assaulted a junior who was working under him. In this case, Now, what happened was that he had filed an application in the Sessions Court, which got dismissed. Then he filed an application in the Bombay High Court, which got dismissed. The application was a request to hold the trial in camera. In camera trial is mandated by Section 327 of the CRPC. Now, what happens is essentially 327 of CRPC states that all the trials that are happening shall be in open court. So anybody can come in, anybody can sit down, anybody can attend the sessions. However, there are certain crimes which are of slightly sensitive nature, and they should not be held in public and in the public's view or in the public's eye, because they kind of they they have a tendency to dishonor the victim, etc. And rape crimes are one of such crimes. In this particular case, the Supreme Court, the Tarun Tejpal, who was accused, has had applied to the Supreme Court to request that this, being a rape trial, should be held in camera. However, the Supreme Court stated that it is not the prerogative of the accused to request for an in-camera proceedings. It is either the prerogative of the victim, or it is for the Supreme Court or the court which is hearing, or the competent court, to see what is the best suited what is the best suited way which is more suitable to the victim, and it is essentially nothing to do with the honor of the accused. Now, proceeding, let us have a look at the most important judgment which has been passed in the last fortnight, which was Sukhpal Singh Khera versus the state of Punjab. In this particular case, the Supreme Court has given a 12-pointer guideline with respect to Section 319 of the Code of Criminal Procedure. Now, first of all, let us have a look at the judges. It is a constitutional bench judgment, so it becomes all the more important. The judges involved in this case are Justices Abdul Nazir, B.R. Gavai, A.S. Popanna, P. Subramaniam, and B.V. Nagaratna. The Constitutional Bench of the Supreme Court issued elaborate guidelines regarding the exercise of powers under Section 319 of the Code of Criminal Procedure. Let us have a look at, first of all, what essentially Section 319 of the Code of Criminal Procedure entails. Section 319 is the power to proceed against other persons appearing to be guilty of an offense. Now, when a trial starts, it an accused is already chosen. During the process of the investigation, there are certain people who are in column 1 who are considered to be the accused, and there are certain other people who are listed in column 2 who the police might have investigated, but it did not eventually file a charge sheet against these people. So at some point of time or the other, the police was apprehensive and the police was thinking that this person might have done the crime, but it so ended that these people did not do the crime. So now what happens is, during the pendency of the trial, the charge sheet was filed, say the charges were framed duly, the trial was going on. During the pendency of the trial, in one of the hearings, the one of the judges felt that there was a need to add one more person to the trial. Now, what shall a judge do? The judge shall invoke the power under Section 319 of the Code of Criminal Procedure. In this, where in the course of an inquiry or in a trial of any offence, it appears from the evidence that any person not being the accused has committed any offence for which the person could be tried together with the accused. That is, if he has to be brought into the trial and tried along with the accused, the court may proceed against such person for the offence which he appears to have committed. Where such a person is not attending the court, he may be arrested and summoned to the court. Then any person attending the court, who is already attending the court and present in the court, although not under arrest and upon summons, may be detained by such court for the purpose of inquiry or trial of the offence which he appears to have committed. Where the court proceeds against the person against subsection 1, that is this, the proceedings in respect of such person shall be commenced afresh, first of all, and all the witnesses must be reheard with respect to this victim per se. And secondly, subject to the provisions of clause A, that is this clause, the case may be proceeded as if such person had been accused person when the court took cognizance of the offence. Now, what we understand from section 319 essentially is that during the pendency of the trial, if the judge feels that there is another person who, firstly, he might be attending the court, and secondly, he might not be attending the court in this case. So, if he's first of all not attending the court, then summons can be issued. Then he might be arrested. Warrants might be issued against him. Arrest warrant might be issued against him, and he might be brought to the court and made an accused and asked such questions and proceeded against. However, if he is, say, one of the witnesses, if he is already attending the court in some other regard, then what the judge has to do is the judge shall simply detain him and proceed against him. So, what are the 12 pointers that the judges gave in this regard? Firstly, if the competent court Firstly, if the competent court finds evidence or under application of section 319 is filed regarding the involvement of any other person committing the offence based on the evidence recorded at any stage in the trial before the passing of the order of the acquittal or sentence, it shall pause the trial at that very stage. So, our takeaway word being, it shall pause the trial. Secondly, the court shall thereupon first decide the need of otherwise summon the additional accused and to pass the orders thereon. If the decision of the court is to exercise the power under section 319 of CRPC and summon the accused, such summon order shall be passed before proceeding further with the trial in the main case. So, passed before proceeding. If the summon order of additional accused is passed, depending on the stage at which it is passed, the court shall also apply its mind to the fact as to whether the summoned accused is to be tried along with the other accused or separately. So our takeaway words being that. So in the first 4 rules, we understand that first of all, when the judge is of the opinion that an additional person has to be added to the list of the accused which are presently being tried in the trial, first step of the judge is going to be to pause the trial. Secondly, he shall call the witnesses. He shall call the witnesses and see if the witnesses, if he wishes that the trial of the fresh accused should be held along with the people who are already being tried as accused or separately. Now, in the next 4 rules, if the court goes for a joint trial, the fresh trial shall be commenced only after securing the presence of the summoned accused. So, if there has to be a joint trial of all the people, then the court shall wait for that accused to arrive. If the decision is that the summoned accused can be tried separately on such other order be made, there will be no impediment for the court to continue and conclude the trial against the accused who were being proceeded with. If the proceeding paused in the above case is in a case where the accused who was tried are being acquitted and the decision is that the summoned accused can be tried afresh separately, there will be no impediment to pass the judgment of the acquittal in the main case. If the power is not invoked or exercised in the main trial till its conclusion and there is a split up or bifurcation in the case, the power under section 319 of CRPC can be invoked or exercised only if there is an evidence to this effect pointing to the involvement of the additional accused to be summoned in the case. So essentially in these rules, what we understand is, firstly, whether the addition of this accused is going to cause an impediment to the ongoing trial or not. So in this case, it will be the duty of the judge to decide which way he wants to go. If he wants to if he wants to add the new accused, then he shall pause the trial, and when he proceeds or when he starts with the trial shall start from from afresh. Essentially, the trial shall start de novo. Now, let us have a look at the other remaining rules in this case. If after the arguments are heard in this case is reserved for judgments, the case is reserved for judgments. The occasion arises for the court to invoke and exercise the power of 319. Then the court shall do rehearing. Now, in this particular case, earlier we were talking about the cases in which there was a pendency of the trial. So witnesses were being heard, and the trial was still going on. And in that particular case, we essentially held that the trial, the witnesses were supposed to be reheard, the evidence was supposed to be checked again, and the accused was supposed to be treated with all the means of natural justice. Now, however, in this particular case, we are talking about a situation where the trial has already been seen by the judges, the judgment has already been reserved, and now the judge feels that there is a requirement for invoking the power under section 319 of the Code of Criminal Procedure. In this particular case, the judge is going to hold a rehearing again. So no respite, no respite to the accused if the judge feels, on setting it down for rehearing the above laid down procedure, to decide about the summoning, holding of the joint trial, or otherwise it shall be decided and proceeded with accordingly. Even in such a case, at a stage, if the decision is to summon the additional accused and hold a joint trial, the trial shall be conducted afresh and de novo. Very important. The fresh and de novo proceedings shall be held. If the decision is to hold a trial, separate trial in the case of summoned accused is indicated earlier, the main case may be decided by pronouncing the conviction and sentence, then proceed afresh against the summoned accused. In the case of acquittal, order shall be passed to that effect, and in the main case, and then proceed against the summoned accused. So essentially, what is going to happen is, if it is felt that there is a decision to hold a separate trial, there might be two cases. The two possibilities might be that the earlier accused, the accused who were being tried from before only, were also guilty along with this accused. So there shall be a separate trial, there shall be a separate set of hearings for them, and if the court feels that they were not guilty, then they shall be acquitted firstly, and then a fresh hearing with the fresh witnesses and the fresh evidence shall take place for the latter, for the accused uh, who was called by invocation of powers under 319 of the Code of Criminal Procedure. And then a whole rehearing is going to take place, and after which a conviction or an acquittal is going to take place. So essentially, these are the elaborate guidelines that are going to be followed in the case of invocation of power under section 319, where accused are called during the pendency of the trial. So that is all for today. That is all for today. Let us hope you learned a lot from the video, and in order to have more legal updates, please don't forget to subscribe the video. Thank you.